Hey, good morning, everyone. Thank you all for taking the time out of your busy day to come to our webinar. We hope that you're enjoying the series of webinars that we've been offering. We're trying to provide content of value to all our clients so that you can sit back, enjoy some good time with some great speakers that we're going to be having this season. My name is Lori Gardner. I am the Director of Sales with Bryson Financial. Today's webinar will be focusing on a subject that is very near and dear to a lot of people's hearts: the family cottage. A lot of us have many fond memories of time spent at the cottage, and most parents hope to transfer that cottage to the next generation to make even more memories. What we often don't think about, however, is how will that transfer take place? How will we successfully pass that cottage down to the next generation, and what are the implications of doing so? We have a wonderful speaker today. Peter Wouters will be joining us, and I'm going to give you a little idea of Peter's background. We could actually have a webinar discussing all of Peter's qualifications. So I'm just going to actually read it out because I don't want to leave anything out of respect to Peter. Peter is a well-respected, much sought-after speaker and expert in the areas of tax, retirement, and estate planning. He provides workshops and seminars for financial advisors, professional firms, and consumer groups throughout the country on the multiplicity of topics, concepts, and strategies covering tax, retirement, and estate planning. Peter is a frequent and repeat speaker at industry schools, conferences, congresses, and seminars throughout North America, and is very active in the industry on a committee and executive level. Peter is actually a co-author of the internationally accredited college program, Your Home and Small Business. He is also co-editor of the Elder Planning Counselor program. He has been repeatedly interviewed on regional and national television, radio, newspapers, and journals as a subject matter expert on various industry issues and developments. Peter has over 3 decades of experience and is a true student of business, as he has 15 different professional designations. His articles have been published in newspapers, industry bulletins, and trade journals throughout the world. He was inducted into America's Who's Who in 2002. Personally, Peter is married, has 2 lovely children, and is very active at his church and the local community. Welcome, Peter.
Thank you very much, Lori. That was a mouthful. I didn't expect you to say all of that. Good morning, everybody. As Lori said in introduction, the family cottage is really a sensitive topic. There's a lot of emotions that tend to go along with the cottage, and that's why you see in the byline here, it's all about keeping the history, memories, and ownership in the actual family. My legal department would be remiss if I didn't mention the fact that today I'm just here to provide you some information. So don't take what I'm saying today as formal legal, tax, financial, or professional advice. I'm here to kind of give you a wake-up call in some respects about some of the issues you may be facing if you're dealing with a family cottage, whether you are the people that own it right now, or you are the people or the generation that wants to inherit it or buy it or acquire it somewhere down the road. Again, please seek out independent financial advice and tax and estate planning advice when you hear some of these issues and you want to talk about it a little bit more with your professional advisor. And by all means, reach out to Bryson Insurance, reach out to Lori Gardner if you like details and some more background information on some of the things I've covered off today. My kids love the cottage, and one day it'll be theirs. That in many respects sums up the feelings that a lot of people have. But how will that actually be done? Will it be done by a gift, a sale, simply putting their name on title? If you intend for your children to own the family cottage property one day, beware. And the reason I say beware is that it may end up costing many times more what they originally paid for the property to transfer that property into the hands of succeeding generations years down the road. And underestimating the tax impact alone is a big error that parents make when they're transferring the family vacation property to their children. Now, there are a number of issues, options, and emotions involved in the transfer of a family vacation property, particularly one that's been in the family for decades and has been enjoyed by a multiple number of generations already. And underestimating, I said, that tax impact is a pretty big one. Where will the children get the money to pay for it? And stemming from that is the strategy of declaring the vacation property as a principal residence. And over the last year, more and more people have said, I'm glad I have that property. That's exactly what I'm doing. I've had to work remotely. I now am comfortable working remotely. I'm able to work remotely. Why don't I live where I really enjoy life? And they're moving up to the cottage and perhaps looking at turning that cottage or vacation property into their principal residence. And of course, in Canada, you can declare just about any property that you spend any amount of time in during the year as a principal residence. Now, this session then is going to cover those topics, providing the issues, emotions, and options on keeping that history, those memories, and ownership in the family on a transfer to succeeding generations. Now, talking about the cottage, and I talk about the cottage, there are many variations of that. Some, of course, are very, very expensive. It could be a cabin, it could be a resort-style vacation property, it could be a chalet, a condo, a fully fledged year-round home that would put many of the homes we have that we live in around the corner from where we live normally to shame. Now, the property may be located in Canada, but under Canadian income tax rules, then again, what about that vacation spot in the southern United States, or the chalet in Vermont, New York, or Utah, or someplace else? Because that all could be part of that vacation property that you may want to pass on to succeeding generations. A tax liability is certainly triggered on the actual or deemed transfer to kids while parents are actually alive. And that tax liability on death or transfer must be made by the estate before the kids or other heirs can actually receive the cottage. The Canada Revenue Agency is pretty sticky about this, but when there's a debt owing, they need to be paid first before anybody gets anything. Liquidity then is required to preserve that valued asset. And if the estate doesn't have sufficient assets, it may be forced to sell the cottage, to sell that vacation property to pay the tax. And that's the tax time bomb that maybe many people are simply unaware of or grossly underestimate. So let's talk about the capital gains rules and what we're actually talking about here. And I'm talking about that tax time bomb. Excluding your principal residence, a taxable disposition occurs at death or when gifted of a vacation property. And right now in the current legislation is 50% of the growth since 1971, or if you acquired that vacation property later than that. And that must be taken into income upon disposition. There's a large gain that could be taxed at the highest marginal tax rates. Because that's got to be taken in income, whatever tax bracket you were, if there's been substantial growth in that property, it doesn't matter what tax bracket you were in, you now are in, at least for that year anyway, into the maximum tax bracket. And that can be pretty onerous in terms of having to fulfill those obligations to the Canada Revenue Agency. Taxes may be paid for as long as a 5-year period under certain circumstances, but interest is going to apply and security must be provided. But proper planning allows that capital gains perhaps to be postponed until the later, at least of 2 spouses. So if 2 spouses own a property, you're passing property between 2 spouses, you may be able to defer, but not eliminate the taxes. And of course, deferral doesn't just mean you're deferring the tax that would have been triggered on the first spouse's death. That tax continues to grow, assuming the property continues to grow in value. Again, the cottage is deemed to have been passed on to the deceased estate for fair market value. And I'm not making this up. It's covered under paragraph 70, bracket 5A of the Income Tax Act for Canadian tax purposes. And of course, there is that 50% inclusion rate of the fair market value, not whatever price you think it's going to be worth, but the fair market value over the adjusted cost base. And that's covered again under paragraph 38A of the Income Tax Act. And the same treatment, of course, applies to a sale or a gift. So those same inclusions, those same reference to the Income Tax Act apply, whether we're talking about a gift, a sale, or an inheritance. Now, before 1982, and some of you that are listening in today or watching the session today have owned these properties before 1982, couples could each declare one property as a principal residence. One claims the home and the other claims the cottage. And they may get a capital gains exemption on 1971 to 1982 growth. But losses on vacation properties cannot be offset against other capital gains, say on an investment portfolio, because vacation properties are classified as personal use properties and losses are deemed to be nil for Canadian income tax purposes. So again, up until 82, there was an opportunity there to do a couple of different things. Post 82, those options, those tactics no longer exist. So it can be a mixed blessing to have this property actually pass on down to somebody else in the family. Real estate booms have triggered significant increases in the value of vacation properties, and that was happening even before the pandemic. The pandemic has just skyrocketed prices in many, many areas. And when you couple that with improvements, today's value is going to be far more than the purchase price. And that does create a ticking tax time bomb in terms of capital gains liability. How does that actually work? Well, let's look at an example. Let's say you bought a property for $100,000 and you added some additions at some point in time. You spent $50,000 way back when wood was a quarter of the price that it is right now, and you had deals and you did some of this yourself, or the neighbors kicked in, or what have you. There was a 1994 capital gains election you could actually make. That disappeared, and if you didn't take it, it's gone forever. But there was that capital gains election, and for the purposes of the example, I'm assuming that you as the owner or your accountant said, hey, there's a capital gains election here. It's going to disappear in 1994. Let's make sure we take care of that. If you elected that, you would add $100,000 onto your adjusted cost base of the policy of your cottage. And what would happen now is, although you initially purchased the cottage for $100,000, the $50,000 in additions and that capital gains election in 1994 would mean that you wouldn't have to worry about any capital gains until the value of the cottage was over $250,000. But let's ratchet this forward 40 years. Remember, you own this property till 1982, you're at the 40-year mark or more. Well, the value after 40 years, assuming only a 6% annual growth rate, would take that property and ratchet up the price to $1.5 million. If you subtract an adjusted cost base of $250,000, you would have a capital gain of almost $1.3 million. $1.3 million of the capital gain. Again, as I just mentioned to you on the slide before, the taxable capital gain is on 50% of that, which is $646,000. I'm going to be generous and say that you only have to pay tax at the rate of 45%. I'm imagining if you've got a taxable capital gain of $646,000, and you have to add that to your existing income, you are now in the top tax bracket no matter where you are in the country. It's going to be 50% or more. But even if it was only 45%, that's $290,000 or $291,000 in income taxes that must be paid before that property can actually transfer hands. Now, again, remember that tax hit increases your tax bracket. And many people did not take advantage of that 1994 deadline for that capital gains election of up to $100,000, which would have bumped up the adjusted cost base. So for most people, that taxable capital gain, the capital gain would have been not $1.3 million, or as it says in the slide, 1292858. You add 100 in front of that, that's the gain. And at 50% now, you're looking at $650,000, almost $700,000, and $290,000 will be well over $300,000 of income tax that actually has to be paid. So what are your options? You said, well, I don't want to pay that. I was not going to sell the property. I'm going to give the property away. And that certainly is an option you actually have. But if you do that, can you actually afford the gift? I mean, not just you as the giver, but or if you are the child right now, but what about the child? Can you afford to have it taken as a gift? Or can the estate afford the bequest? Or must the family cottage be sold to pay the tax? It's going to have to be paid by somebody. So assume that the existing ownership structure is set up by the parents and it's done as a joint last survivor deal. Let's consider a gift versus a sale. What would happen then if the property was jointly owned, and we're talking about a Canadian property, by the way. I'll get into what happens if you're in the United States with a property that you say is jointly owned. If the property is sold to the child, then there's no protection from a division of family property if the child is married, or the common law, depending on the jurisdiction. So yes, you can sell the property to the child, but what happens, of course, that's not inherited. And if there is marital strife or a breakdown in the marriage relationship, and the child then has to go through divorce court or whatever else like that, that vacation property is now up for grabs. And by the way, a gift or a sale has exactly the same consequences to the parent. They're deemed to have sold it at or have received fair market value. It doesn't matter what price you paid, they're deemed to have received it at fair market value. But that's not the issue necessarily for the child. Here's why. The way the Income Tax Act works in Canada is that if the sale is made at a nominal price, and by that I mean, okay, the cottage was worth $500,000. And what I'm going to do is I'm going to transfer it to my child. I'm going to give to my child for $1. Just give me $1, make it legal. We'll change the title. That becomes the adjusted cost base of the child, which means that the parent has to pay capital gains tax on the fair market value, the increase in value from $500,000, which is worth right now, and maybe that thing was worth $50,000. So there's a $450,000 capital gain. The parents will have to pay tax on the basis of that cottage being worth $500,000. The child assumes it for $1. If the child goes out and wants to sell it a year or so later, they're deemed, and there's been no increase in price, they're deemed to have sold it for $500,000 because that is still the fair market value, and they'll pay tax on the same thing twice. That is double taxation. So the parent pays the capital gains tax on the original increase from the adjusted cost base, and the child pays the capital gains on the difference between what they paid for it and the fair market value when they actually got that property from their parent, plus any further growth that actually occurs. So gifting it at a nominal price really doesn't work to anyone's advantage. In fact, it is very disadvantageous to actually do something like that. Clients should look at gifting if they're feeling really benevolent or a child can't afford the fair market value. And what they could do as an option is perhaps take back a mortgage or a promissory note that can be forgiven later in life of the parent or as a testamentary gift. And so they're gifting it, but they're taking back a mortgage. The mortgage is forgivable, but the thing is actually passing on a fair market value. The child doesn't have to come up with the money. Parents, of course, are still going to have to declare the sale of that vacation property. They're still going to have to pay tax and any capital gains on the increase in value between, what they paid for and those improvements and that fair market value of the property. But take care in charging and collecting interest on the note or mortgage if you decide that, the kids really can't afford it. I don't want to be in a situation where there's double taxation, where I got to pay tax as a parent on the increased value of the cottage, and the child then is stuck in the same situation. In fact, in a worse situation. At least when I when I get taxed on it, if I bought the place for $100,000 and sold it for $500,000, my capital gain is $400. When my child acquires it for $1, their capital gain, if they sold it a year later, would be $499,000. The capital gain is even bigger for the actual child. So by taking back a mortgage or a promissory note that you forgive on death, it goes on record that the parent, it doesn't change anything in terms of the taxes for the parent, but for the child, their fair market value truly is the value of the same value as what the parents actually transferred it to you for, not the dollar, but the down payment they made or the mortgage or the promissory note. That becomes the actual value plus any consideration they actually pay. And that avoids at least the double taxation situation. Now, a lot of people think, okay, why don't we just sell the cottage to the kids? Instead of just transferring it to them on title, well, why don't we just sell it to them? And that certainly is an option. The issue there is that if you sell the cottage to the kids right now, the tax liability certainly is fixed for the clients. Future growth is taxed in the kids' hands. You can get favorable payment terms that can be arranged, low or no interest or testamentary forgiveness, as I said before. And the capital gain can potentially be spread out perhaps over as much as 5 years. That becomes a possibility for the parent and the child. So in terms of cash flow, that can sometimes make things a little bit easier. A lot of people, though, are bothered by probate and estate settlement costs, and they're interested in ideas of how property like the family cottage, this vacation property, can be transferred outside of their estate and avoid probate and estate administration fees where applicable. And it's not that probate necessarily is all that expensive, but when you add in all the estate settlement costs and the sheer time it takes to settle it, and the fact that you really can't enjoy it until all these taxes have been paid, well, it's not unusual for an estate to take a year, 2 years, 3 years. And what happens in between in terms of this limbo that people are in about whether or not that cottage can actually pass on hands. For business owners, in particular, transferring the cottage outside the estate may also avoid any potential claims against their estate by creditors or other interested parties. The children get to enjoy it now. They get to experience both the pride of ownership and the responsibility of upkeep, including taxes and utilities. You as the parent, as the present owner, are assured the cottage stays in the family, and the tax impact of the transfer, of course, will depend on the consideration paid. What did the child actually pay? What was the size of that promissory note? And that determines part of that tax liability. So what price do you set? Because again, that price now becomes very, very important. The proceeds of disposition, the actual sale price in an arm's length transaction, is used to calculate capital gains. But when you're passing on to the family, that's a non-arm's length. And so if it's gifted or sold to children for less than fair market value, the Canada Revenue Agency, or the CRA, still deems the transfer to occur at fair market value, whether it's done during your lifetime or it's done as a testamentary gift. And it's deemed to be a non-arm's length transaction. If it's sold, the adjusted cost base for the child is the amount they actually paid. And that produces that double taxation situation for the difference between the selling price to the child and the actual fair market value for the parent when the child disposes or is deemed to dispose of that property. So gifting at death, in fact, may then be a better deal than selling it for $1 during your lifetime. If parents want to transfer or sell their vacation property at less than fair market value to the kids, then consider selling it again at fair market value and taking back a promissory note with no interest or with an interest charge, and that at least will set a higher cost base for the children somewhere down the road. If the cottage is transferred to one of several children, then at death, the outstanding loan reduces the share of the estate for the child with the vacation property. That's what should be happening, right? It shouldn't be a forgivable loan and they still get the double dip. That outstanding loan should reduce their share of the estate so that you have some type of equalization between the child assuming the cottage or vacation property and the other children who have no interest in the property or perhaps now acquired a property on their own or through marriage now have a property through their in-laws. If a debt or a promissory note or mortgage is to be given at death, then ensure that the will states that this is going to actually be happening, that forgiving the debt before death, of course, will trigger negative consequences. So make sure it happens after death. Ensure the parent structures the promissory note with the vacation property as security in case the child has creditor problems, so the parent can certainly rank at least equal or above other creditors, and in case the child cannot keep up any loan repayments. You may have been in a situation where it's the opposite that's happening. Maybe the parent doesn't have a lot of money. They have the property, but not a lot of extra cash. The children have done very, very well. And so what they want to do is sweeten the pot. If the cottage is actually sold for more than fair market value to the children, perhaps because the parents need some extra money, the children are quite affluent, then the proceeds of disposition, that price they actually paid for it, will set the value for capital gains liability to the parent. So the capital gains liability of the parent actually goes up. But again, since this is an arm's length transaction, the deemed sale to the child will be at fair market value. So what happens there? That means the growth from the fair market value, not the price they paid for it, not the purchase price, will be taxed as a capital gain. And again, that produces a double taxation situation for the difference between what the kids actually paid for the cottage and what the true value of the cottage actually was, plus any further growth on that cottage. So again, selling it for more than fair market value doesn't necessarily make a lot of sense here because the parents pay more capital gains, and the child will pay capital gains on that same extra amount of money in addition to any further growth on the actual property. To decrease the impact of capital gains, then, remember that the cost of property, of course, includes renovations and improvements, but not regular maintenance. So the cost is typically more than the purchase price, but in order to be able to factor in those renovations, make sure you keep records. Make sure you've got documentation about all the money you actually put into it so that you can demonstrate that this truly is added on to the adjusted cost base and should be added on to the adjusted cost base of the actual property so that you can reduce it from the actual capital gain on a sale or a transfer. So again, if you sell the cottage to the children right now, the proceeds can certainly serve as an income source for the parents. That's terrific. Maintain the cottage, of course, is time consuming. It's expensive. It may just become too much trouble for aging parents. The cost of upkeep can be redirected, of course, to other things. So parents now have money in their hands, and whatever they were spending on maintenance can be redirected to other issues, and the proceeds can certainly supplement their retirement savings or supplement their lifestyle. So that's a good reason, perhaps, for transferring that college or selling the college, even to the children, while the parents are still alive. What if let's look at some of the other ideas, some of the other issues and concerns and options when you're transferring ownership. You could jointly own the property of the children. What I'm going to do now as a parent, I'm going to put my vacation property into joint ownership with my children, a joint ownership structure. Recognize that when you do that, that also triggers a capital gain for the portion transferred. And it transfers, the capital gain is triggered for the fair market value of the portion that's being transferred. So if you transferred half of it, because you're doing that with one child, then half of the capital gain that's been accrued at that point in time will have to be paid by the parent at that time. That's when it's due. Parents can certainly retain some measure of control and share in the upkeep of responsibilities and taxes, but the property, of course, can now be exposed to the creditor and or family problems of the child or children, including marital claims. You got to think about the fact that when the sharks come out, the ex's in-laws now become outlaws with hired guns in tow in the form of lawyers. So that can be problematic. For example, the other problems that occur with ownership transfer of the kids is that proving the true intention of the transfer. For example, a parent transfers ownership of the cottage to one child of several. Is that a gift? Or is it simply a probate avoidance strategy? Perhaps an estate planning scheme. You may avoid these issues by completing a declaration of intention for joint assets with proper legal advice, but make sure this is well papered, well documented, or the courts could rule that property was really held as a presumption of trust and goes back into the estate, perhaps goes into the residue of the estate. Your will says the residue goes to my distant cousin. Well, who actually is going to get this property right now? And now it's sitting in the estate subject to both probate and estate settlement costs. So that could be a very, very messy alternative. Again, when you're looking at transferring title and jointly owning the property with your children, the question I have and the question you need to ask yourself is that when you're transferring it, are you doing it with joint title with rights of survivorship or as tenants in common? With rights of survivorship, the interest of each party goes to the survivor outside the estate. So the nice thing about it is that with rights of survivorship, the property transfers outside the estate to the surviving title holders. If it's tenants in common, then that share actually goes to that person's through that person's estate. It doesn't go to the survivor. It can go to anyone that you actually choose it to go to. Tenants in common sometimes might be nice if I say no, I have my property in joint ownership with a child, and when the child dies, that ownership should actually transfer down a generation to their child as opposed to coming back to me. If that's the intention, you don't set up rights of survivorship. You set it up as tenants in common. Again, if it's joint tenancy with rights of survivorship, each joint owner has an undivided interest in the entire property. That can become problematic again when there's marital claims or discord or whatever. With siblings, the deceased family is left with a tax bill since that's a deemed disposition. If the property passes to the siblings, not the immediate family, that can actually happen. Other problems to consider, including proving true intention of the parent and transferring that property to the joint ownership with the child. So again, make sure this is very, very well documented. Otherwise, you could face challenges by creditors, probate court, siblings, and the probate issue is dwarfed by all of these other issues. Other questions I've got when you do that sort of thing is that who's covering the ongoing maintenance on jointly owned property? Who's responsible for all of that? If it was the parent, was that a series of further gifts? And that begs the question, how do you prove it was a gift? Was it actually documented? Did you cover off all those other issues too in terms of property taxes and maintenance? I mean, if it was truly jointly owned, then shouldn't everybody be pitching in? And that presumption of resulting trust means that the surviving joint owner must prove that true gift was intended. So when you're putting something on joint title, you're actually gifting that property away. And you better be able to defend that against any alleged conflict of interest, any self-serving. And if you're not able to prove it, that property ends up going back into the estate again and could be subject to the claims and of other siblings, let alone any other creditors. Let's look at a particular situation here. This is Donaldson versus Braybrook, a 2020 Ontario Court of Appeal case. Interesting, this is 2020 Court of Appeal case. And as you'll find out in the next slide, mom died in 2007. So these cases, if they have to go to court, can take a long time to settle. Margaret had 4 children. They were all allowed very generous access to the cottage. Margaret secretly transferred ownership to herself and 2 children as joint tenants. Joint tenants as the remainder in fee. Well, some lawyer dreamt that up, but it was very vague wording. Other children listed as additional transferees having a life interest. And that wording was so vague, it triggered disputes on mom's passing as to what actually was intended there. What did mom intend? And was it consistent with how those terms could actually be interpreted? The will, which was made at the same time, actually said to hold back the estate residue for 5 years to pay the cottage expenses. So what was going to happen there, if you looked at it, is that the transfer would happen outside the estate. The new owners would be 2 of the 4 children. The other 2 children would have a life interest in it. They could still use the cottage, that vacation property, for years on end. And there was supposed to be at least 5 years worth of money still leaving in the estate to pay for those cottage expenses before people would have to reach into their pockets and pay for it on their own. Sounds so good so far? Maybe not. Maybe you already see some problems. Well, here's where it gets ugly. Margaret died in 2007. There were 2 joint partners. The 2 joint owners severed the joint tenancy. They said, you know what, we don't want the cottage. One was moving out west, and they said, let's get rid of that. So they wanted to sell the cottage as tenants in common because one was moving. But they needed the other 2 children to renounce their life interest. Remember, 2 of them owned it, but 2 of them had a life interest in the property. They were still able to use that property. That was the intention. So in order to sell the property, the 2 joint owners needed the consent of their 2 siblings to be able to do that. And one child agreed to renounce the life interest. The other one refused, claiming that she was an equal owner. Wow, I mean, that's not necessarily what the will said. That's not how the paperwork was worded, but the one child said, I'm not transferring a life interest. I'm actually an equal owner. Well, how is that actually going to spill out here? Who has rights to the cottage? I mean, who really does pay the expenses on a situation like that? So what the court ruled, and this had to go to an appeals court, so there was an initial ruling, it went to appeal, and the Court of Appeal ruled that there was no presumption of resulting trust. The court was satisfied that the documentation in place and mom's intention was for 2 of the 4 children to actually have an ownership interest in the property, but that all 4 children would continue to be able to use the property. And that made it kind of hard for the 2 that wanted to sell. So title remained with the joint tenants, but there was a non-exclusive lifetime access to the holdout daughter. So the one child said, I'm going to renounce it, that's fine. But that holdout daughter said, yes, I can continue to use that cottage, not exclusively. I have to work that out with at least my 2 other siblings. But on my passing, there's no further rights to get passed on to anybody else in the family. And if at that point in time I decide to change my mind or I pass away, then what happens, of course, is that the 2 children who own it could actually sell the cottage at that point in time. Are there other transfer options? And yes, there are. Again, the Canada Revenue Agency can treat a property owned by a corporation as a shareholder benefit. And up until 2005, what would happen is that people would actually take their family vacation property, whether it was located in Canada or some other country in the world, and actually have it owned by a single purpose corporation. A corporation was set up to own that property. Well, in 2005, they said, we don't like these single-purpose corporations. So what we're going to do is we're under a new section of the Income Tax Act, subsection 15.1, we're going to charge people for the value of the received usage. So if you are a shareholder of that corporation that owns this vacation property, the Canada Revenue Agency says, well, you're using that property? If you had rented it out, what would be the fair market value of that rent? And it's because you as a shareholder are getting a benefit as a shareholder, that is a taxable benefit. So now you're going to have to pay taxes on the fair market value of what it would cost someone to rent or lease that place for the week, 2 weeks, 5 weeks, 8 weeks, 20 weeks of the year. So that made that type of a move pretty unsatiable to people since 2005. The other problem that happens, of course, is that when you transfer that property to the corporation, what's lost is the opportunity somewhere down the road to use that cottage as a principal residence exemption. That deal is gone. And it certainly triggers a capital gains calculation on the transfer. So at the point in time that the cottage is actually transferred to the corporation, that's a deemed disposition. So whatever the cottage was worth back in 1971, until the point in time that it's actually transferred to the cottage, is a capital gain. That capital gain has to be paid for, and then that increased value becomes the new fair market value, the starting point for the corporation, and then any increase down the road is then paid by the corporation. What if you transfer it to a trust? You say, well, that would solve some of the problems here by transfer it to the trust, because this way I can set up different classes of beneficiaries. I can make sure it stays in the family. By having a trust, there's all kinds of things that I can actually do. Recognize that a transfer to a trust also is done at fair market value. That also triggers a capital gain on any unrealized capital gains. There's that 21-year rule that exists as well, which assumes that that cottage is resold every 21 years, and that's going to create some cash flow issues. It's not that you did sell the cottage, it's that the Canada Revenue Agency says every 21 years, do new calculation of that asset. If it's increased in value, that's a capital gain, and there'll be taxes owing at that point in time. You do, on the other hand, have better long-term control in terms of who's included in that family trust, who gets the rights to use that process. You get different classes of beneficiaries in terms of who has priority in using that property, how it can be passed on down the line. You can certainly roll out the property to the beneficiaries at the adjusted cost base. So although there may be tax triggered on moving the property into the trust, there can be a deferral of that capital gains when you move it outside the trust. When it's rolled out to the beneficiaries could in fact claim a principal residence exemption, and it's certainly easier if you're purchasing a vacation property via trust where a property has a loss or a small accrued capital gain. So if you want to do this, maybe an easier way of doing it on a go-forward basis instead of transferring the existing property is to use new money, buy a property to begin with. You skip that fair market assessment at the front end, and the money is sitting in the trust, which then owns that particular property. There are exceptions, of course, and again, for some of you that are age 65 and older, there is the opportunity to transfer a cottage to an alter ego trust, which is a trust you set up for yourself when you're 65 years of age, or a joint partner trust where you set one up for you and your spouse. You can do that and avoid triggering capital gains on that transfer. So again, the trust may allow for some flexibility in administering the property. It lets the people who may now be grandparents pass some responsibility onto their children and grandchildren without giving up all rights to use the cottage for themselves or even to earn income from it, to get it as rental income. But of course, that creates problems as well down the road. No one other than the grandparents may receive or make use of the income or capital of the trust before the later of their deaths. Work that into the arrangement. That's important because a failure to meet that requirement would adversely affect the tax-free rollover of the cottage to a trust. Transferring a property to one of 3 personal use trusts mentioned can defer capital gains taxes and keep the property outside of the grandparents' estate. That's the advantage of an alter ego or joint partner trust. That could actually happen. And what you do then is that you could name the grandparents, in this case, the grandparents' children, as contingent beneficiaries of the trust. And when both parents are deceased, the trust would distribute the cottage to the children. So you bypass the estate and bypass those estate settlement costs. Cottage is now in the hands of the kids, and they can deal with capital gains problems down the road. How about looking at the cottage as a principal residence? And again, this has become much more popular, certainly in the last year with the pandemic. For example, parents may have downsized to a condominium in town, spending much of their time in a cottage, or we have people that have simply moved because they're working remotely and now can do that permanently. The cottage could, in fact, be classified as their principal residence, and the capital gains problems down the road transferred to their condominium, which may not occur at the same type of growth in value. So you've decided to downsize to a townhouse in town. It's not a bad spot. It may not increase nearly as quickly in value as the principal cottage, as the cottage you've got right now. You decide to declare your principal residence, take that principal residence exemption and a declaration on the cottage. Why? It's not just because you're spending more time there, but from a tax perspective, it's the property that's going up further in value and quicker in value. And if that happens, you want to be able to shelter that increased value from capital gains tax when you compare it to what could be the increased value of that condo or that place you're renting in town. You now are required, of course, to report every disposition of a principal residence on your personal tax return. It doesn't matter if the gain is fully sheltered from income tax or not the principal residence exemption. And again, up until 2016, that tax year, the Canada Revenue Agency didn't require you to report the sale of a principal residence if the gain was fully sheltered by the exemption. But effective now, and we're now in our 5th year, if you don't report the sale on your income tax return, the property disposition will be subject to an open-ended reassessment period. What does that mean? Well, the normal reassessment period for an individual taxpayer is generally 3 years from the date of the initial notice of assessment. So we just filed our tax returns for 2020. We can go back 3 years there. But an open-ended assessment period means that an extended period of time has been added outside of the normal assessment period for any tax year where the taxpayer does not report the disposition of a property in that particular year they disposed of it or got rid of it, and doesn't file a tax return for the year in which they sold that property. If the Canada Revenue Agency assesses income tax on that property disposition, the 3-year limit does not apply, and penalties will be payable, and interest will be payable in addition to the actual taxes owing. So could be problematic. So if the clients are looking at you and I'm talking about Bryson insurance clients, so not all of the people listening today are actual clients. Some of you are perhaps other advisors. You could have the home sold and declare the vacation property as a principal residence. You need to own that property alone or jointly. You must live in that property in any given year, just a minimal period of time. The family unit, again, if you're looking at a husband and wife situation, can only designate one property as a principal residence for any given year. In terms of the size of the property here, and that may make a difference here if you're looking at a vacation property or a cottage property, the property size, if it's up to half an acre, qualifies as part of the principal residence. More can be included if necessary for the use and enjoyment as the residence. But in order to do all these things, you also need to be a Canadian resident. The principal residence, by the way, can be anywhere in the world. So for Canadian income tax purposes, that principal residence exemption can apply whether you could have owned a home in Canada, nice vacation property down in the United States, which is increasing in value tremendously. You decide to sell the home in Canada, maybe rent a place or buy a small condo. You can, under Canadian income tax law, declare your vacation property in the United States as your principal residence. But again, note the difference between principal residence for capital gains purposes and treatment and residency for income tax purposes. Think about U.S. Internal Revenue Service claims on deemed residency and income tax filing and reporting requirements. So it's not as simple as it looks on surface. And also watch foreign taxes due or triggered, because you may get a foreign tax credit, you may not, when you start selling those foreign properties. So what about declaring a rental property as your client's principal residence? Again, rental properties cannot be classified as a principal residence, even though the owner stayed there for a certain period of time. Now, there's a special 4-year exception rule before or after the entire property is used as a principal residence, when it could be designated as a principal residence and no other home is claimed, and you file a special election. And that, again, allows that capital gain to be deferred and tax paid only when the property is eventually sold. And it allows you as a taxpayer to treat the property as your principal residence for up to 4 years before it is actually occupied, or as your principal residence. What else do we need to know here? Well, let's look at the actual calculation. What is the capital gain? Again, a capital gain, but not a loss, can be reduced as follows. So the reduced capital gain, when you turn your vacation property into your principal residence, is you look at the entire capital gain that's available, and then you add 1 times the number of tax years the cottage was a principal residence and the owner was a Canadian resident. So you take the capital gain, you multiply it by 1 times the number of tax years the cottage was a principal residence and you were a Canadian resident, and then you divide that by the number of taxation years after December 31st, 1971, or later when you acquired it, when you actually owned it. So the fraction of the time that you declared as a principal residence divided by the total times you owned it, that becomes the portion that will be a reduction in the actual capital gain. So let's look at an example here as a principal residence. A homeowner purchases a cottage in 1995, so it happens after that personal capital gains exemption is gone. They sell their home in 2005, and then they designate their cottage as their principal residence, and they pass away in 2025. And the capital gain on the property is now $500,000. So it doesn't matter what you purchased it for. I'm just going to focus on the capital gain. So the capital gain on the property now is $500,000. If that property now, as you know, back in 2005, so 10 years after you bought the cottage, you now turn that into your principal residence, what's the reduced capital gain? Well, again, here's the formula. You take the capital gain, which is $500,000, and you look at the number of years that, in fact, you used it as a principal residence, declared it as a principal residence. You divide that by the number of years you actually owned it, and it means that the capital gain now has been reduced to $354,000. And what does that actually mean? It means that the reduced capital gain here, when you subtract that, is about $145,000. Half of that is taxable. And if you pay tax on half of it, your bill now is about, well, a lot less money than you actually thought. But it still is a capital gain. And of course, you do get a big break here when you do that calculation. Again, if you'd like to see that formula again, please reach out to Lori. I did write an article on this. Again, reach out to Lori after the session, and she can talk to you about how this actually works. And there's a formula description in that particular document that I actually wrote on using the lake property as a principal residence. What are the possible opportunities when you actually pass away? Because sometimes this cottage is actually held until actual death. So what happens? In terms of the actual property, solutions at death, the estate or the children could pay the income tax liability from current funds, but are the funds even available? Unfortunately, to preserve as much of the estate as possible, liquidation may in fact force the clients to sell that event to protect the rest of the estate. And only they will command the highest price when the cash is needed fast, right? So if you need the money, selling to the third party, what are you actually going to sell it for? If the intent is to keep the cottage in the family, does the will in fact give explicit instructions as to which assets are to be sold to pay the tax liability? It has to be sold. You don't have to sell the cottage. What are you going to sell instead of that? So is there any direction in the will that says, here's the order of things that can be sold, sell that, and preserve this? And by the liabilities, I mean the capital gains tax, any income taxes, unregistered funds, the estate settlement costs, accrued debt on reverse mortgages, unpaid medical expenses, funeral expenses, land transfer taxes. There's all those things that actually have to be paid for. Where's the money from that going to come from, if not from the sale of the cottage itself? It's going to come from another source. Where's that money actually going to come from? Money could be borrowed to pay the tax. Yeah, you could do that. Can you actually get that credit? Can you get it in the actual amount you need and on favorable terms? And what would the non-deductible interest rate actually be? You can't deduct the interest in this. This is not a business deal. This is for personal property. So that non-deductible interest rate, you have to add on to the purchase price. You have to pay that money back over a period of time, unless, of course, you can arrange for some type of a long-term line of credit or a mortgage to make that happen. Money could be paid in installments after death. The question then is, if it's paid in installments, would the estate or children be able to provide the necessary security to the government to pay it off that way? Would the estate or heirs have adequate cash flow to repay the amount owing with interest? And again, what would the interest rate charge be if this thing is being paid over time? Let's say the purchase price of the cottage was $50,000. In the actual annual growth rate was 6% in this particular example. I'm going to say again, when the cottage is transferred, it's a 45% tax bracket. Depending on the value, of course, it'll probably be north of 50. And I'm going to say there was no capital gains election that was claimed on the cottage. What's the size of the actual problem? So 10 years down the road, that property has grown from $50,000 to $90,000. There's a $40,000 capital gain. Half of that is taxable. You get $9,000 of tax. That's not a big deal. But I want you to look down towards the bottom. Let's look 40 years down the road. 40 years down the road, that $50,000 property at a 6% growth rate in terms of value increasing is now worth $500,000. It's 10 times as much. And the capital gains problem right now is $104,000. That's the actual check you have to write to the Canada Revenue Agency. 50 years down the road, it's almost $200,000. And that taxable gain, of course, inflates total income. So the tax payable is $200,000 50 years down the road, but that taxable gain, $435,500, and that bottom line right now, that's what you have to add on to your income. And that's what's going to drive up the taxes that you pay on just about anything. If you're looking at any type of tax credits and breaks, most of which are net income tested, you're going to lose all of those. Let's talk about vacation properties in the United States as we're getting towards the end of the session. A key difference is that Canada assesses a capital gain on the increased value on death. The U.S. applies an estate tax on the entire value, not the increased value, but the entire value. These are different taxes that don't offset each other perfectly, and foreign tax credits then are only at a federal level. So you do have the potential for double taxation in the United States and in Canada. Now, U.S. estate tax exemption exists if the U.S. assets are worth less than $60,000. Get about a $13,000 break here. And you probably heard about the fact that, well, in the United States, there's an estate tax exemption here. Your estate can be worth up to $11.7 million U.S. in 2021. You wouldn't have to worry about that. But Canadian residents don't get $11.7 million credit. They get proportionate access. And the access they get is simply divided as follows. You take all of your U.S. assets and you divide it by your worldwide assets. And that's the fraction of the $11.7 million you get. So if the vacation property down in Florida or down in Arizona or something is only worth 5% of the entire value of your estate, you only get 5% of the $11.7 million. That may be enough. It may not. And of course, you start looking at what gets included in that. Well, life insurance is included in determining the value of your estate. There's no tax payable on it, but in fact, it's actually included to determine the rate at which you pay tax on everything else. And regardless of what happens, if that property, that U.S. Citizens property is worth $60,000 U.S. or more, you must file a U.S. tax return. You must file that. Now I'm talking about federal rules right here. Again, keep in mind that 16 states have independent estate and or inheritance taxes. So that will be over and above these taxes, and those thresholds are going to be much, much lower. Now let's look at what happens if you look at that change of use for a principal residence exemption and you're looking at an American property to do that. Again, let's look at the Canadian issue and the American issue. Again, we're assuming that you owned and used the home as a principal residence, have to have used that principal residence for 2 out of the 5 years prior to the actual sale of that property or deemed sale. The period of non-qualifying use starts from January 1st, 2009. That's when these rules came into place. So what you look at is a total period of non-qualified use over the length of time you actually owned it. So much like the Canadian rules, what happens is that I used it as a principal residence for 4 years. I owned it for 20 years. 4 divided by 20 times the gain on the sale of property. That's going to be the capital gain you might have to worry about or not have to worry about. The exclusion, by the way, cannot exceed $250,000 US. So if that vacation property has gone up a lot in value, you're going to be capped at $250,000 US when that happens. So what are some of the other options you've got to look at right here? If you're a Canadian with homes in the United States, I know from Canadian tax purposes, you can claim that U.S. property as a principal residence, but you got to consider income taxes, U.S. estate taxes, U.S. gift taxes, probate issues in the United States, and there's also issues, fancy acronym there, about issues when you actually sell it, because when you actually sell that property, Typically, there's about a 30% withholding tax that must be held on or a 15% withholding tax, or 30, depending on where you actually live, where the property is, that has to be withheld as an offset against any taxes that are actually owing, and they've got to be paid by they're held back by the buyer. Again, if you want to avoid or defer owning that property in the United States, you can. But before I go into that, if you've got that price in that property in the United States, you worry about the price of taxes and that sort of thing. Consider, how did you purchase that property, or how do you purchase or own your Florida or U.S. property? Do you own it personally? Do you own it with your spouse? Do you own it with your children? Did you use a company? If you used a company to own that property, was it a Canadian company? Was it a U.S. company? Was it a U.S. limited liability corporation? Did you use a partnership? Did you use a trust? Was it a complex trust, a revocable trust, a land or a bear trust? All kinds of options that exist that some of you are very well aware of if you own vacation property in the United States. And the information and answers to these questions are certainly beyond the scope of today's session, but you could invite me back at some point in time, and we could focus just on that. Clients need to deal again with a lawyer well-versed in cross-border tax and property planning to get that right, so that the structure minimizes tax and legal consequences in both countries. So when we're talking about avoiding or deferring U.S. tax, again, joint ownership should not be as joint tenants with rights of survivorship, typically. And the reason that specialists say this is that you want to be able to optimize flexibility in minimizing estate taxes, or if you want to unwind the original deed and set it up as tenants in common, think about the following. A surviving joint ownership. So a surviving joint owner needs to prove that they contributed equally to the purchase of the property. If they cannot prove that, then the full value of the property is included in the first spouse's estate for U.S. tax purposes. You've got to be able to prove it. So tenants in common, nothing really to prove. You say we own it equally or tenants in common. They don't tend to answer those questions. If you move to that perspective, or you want to move it to that perspective over time, where you got a joint tenancy with rights of survivorship, one thing you might want to consider is an annual gifting to a spouse to systematically transfer equal ownership of the property from the contributing spouse or majority owner under U.S. law to that minority contributing spouse. You can do that up to $159,000 a year, so it doesn't have to take a long period of time. Understand, of course, you're redeeming the property each year. It does trigger Canadian disposition taxes in the form of capital gains each time that transfer is done. You could set up a non-recourse mortgage that yields a dollar-for-dollar reduction against the value of the real property that's included in the estate. Typically, the maximum non-recourse mortgage is about 60% of the equity or value of the property or home. If you haven't bought a U.S. property, the payer could set up a trust and fund it with cash. The spouse could be the trustee, not the settlor. The trust is a taxpayer in the U.S. and Canada and the owner of the property. The trust beneficiaries can pay rent, the expenses, but no living beneficiary can contribute to the trust to avoid any type of proportionate interest classification for U.S. estate tax purposes. Capital improvements come from the settlor or the grantor. Taxable events are synchronized when you do that for Canada and U.S. foreign tax credits, which is a good thing to know. On the sale of a property, you can take the proceeds and buy a new place. And on the death of the spouse trustee, the settlor spouse must pay rent to use the property to avoid any type of tax challenge. But you can avoid a lot of the shareholder benefit issues with corporately owned policies and corporately owned structures and properties that way. I have an article here. I'm not going to spend a lot of time on it about the family cottage as a matrimonial property and marital breakdown. Again, reach out to Lori. I wrote this is that people will ask, well, what happens if we break up? Can the cottage actually form part of joint property or property that's subject to marital split-ups or marital property or divisible property? And that can actually happen. There's an article there that you can pick up from Lori to learn more about that. And a couple of articles on there about the second home. Does the second home, is that always a matrimonial home? Always included, or is it not included? So we're not only talking about the cottage being a principal residence, but what happens if it's just a vacation property? Can that actually be drawn into any type of division of property or be claimed as a matrimonial home? Let's go to solution mode here. We have just a minute or two left right here. One of the possible solutions is to use appropriately designed life insurance to actually pay those taxes. Income tax liabilities on death and life insurance creates an immediate tax-free cash to provide the solution. You would set this typically up on a joint second to die policy, which means you buy one policy to cover both the husband and the wife, or the wife and the wife, or the husband and the husband. A very economical way to provide cash to the estate, because the tax will be triggered on the death of the second person. Many life insurance plans are suitable for paying a state's income tax. It can be available at premiums of anywhere between 1 to 5% of whatever amount you actually purchase. You factor that in over a period of time, even if the average for 60-year-olds is about 2%, a little around 2%, that's a pretty cheap way of doing it. You can't rent money for 2%, and you still got to pay back the principal. You can buy insurance at about 2% if you're 60 years of age, and when you pass away, the full face amount is paid out to the estate or to beneficiaries to cover off all these issues. And all of that, of course, can be customized. Who owns that policy and pays for it? The kids. They're the ones that are going to be benefiting from this. They pay for it. They own it. It matures and is paid out when both parents have passed away. It's used to pay off any capital gains and associated costs of keeping that family cottage and property in the family. Kids want it, let the kids pay for it. And it can also be used to equalize the inheritance if the cottage is not shared amongst the siblings. So the money that's being used is actually paid for the cottage, and the money that goes to the estate be paid out to other kids who are not interested in the cottage or have cottages of their own. Let's look at John and Mary Cottage. He's 65, she's 62. They're both non-smokers. For purposes of life insurance, we actually give them both of a break, treat them both as if they were just 55 years of age. They need $250,000 in their passing. They want this to happen no matter when they happen. They could live a long, long time. So with permanent life insurance policies, level deposits, here they are. Remember, he's 65, she's 62. It's going to cost them 2.3%. Decide they want to pay this all off in the next 20 years, it would be 2.9%. Which choice do you really prefer? And certainly either one of these options is cheaper than the alternatives we talked about so far today. An insurance policy as a cottage legacy builder is the best kind of insurance to keep the history, memories, and dreams in the family. It's efficient, it's tax-free, relatively inexpensive when you compare it to the other alternatives, and it certainly provides peace of mind for everybody. So in closing, there is that common sentiment about keeping the cottage in the family, but how is that going to be done? The session covered a number of issues, options, and solutions that dealt with keeping that history and memories and ownership alive when you're considering a transfer to succeeding generations. So I'm encouraging you today to let the conversations begin. Discuss it amongst yourselves, discuss it with Lori, and consider what options may work best for you in your particular situation, and get working on implementing a plan that keeps that sentiment about keeping the cottage and the family alive. Thanks for listening in today. I don't think about time now to answer any questions, Lori. I don't think I do. There may have been some questions coming in, but as I promised everybody, I will provide written responses to you, Lori, and you can send them out to all the attendees.
Excellent. Thanks so much. We appreciate that, Peter. Anyone with any specific questions that weren't covered, feel free to drop me an email and I can get the answers from Peter. I also wanted to thank Bob Gore and Chris Macris from Bob Gore and Associates Professional Accountants. You've provided some invaluable information in the chat, which helped us a lot. Otherwise, unless Peter, if you have anything else, I think we've pretty much covered everything.
Great. Thank you. Hope you found this informative and hope it incents you to actually start that conversation.
Excellent. Actually, if you go to our website, I was going to say my email address there, but Kyle, my colleague, has already provided it there as well. And I can also reply with some of the articles that Peter has written to answer any of your questions or to explore the option of life insurance as a way to deal with these capital gains issues as well. Thank you so much, everyone. Have a wonderful day. And thanks again, Peter.
Thank you.
Thank you.